Jonathan, and thanks for the wonderful conference. Sort of after I put the kids to sleep yesterday, I had to leave. Sorry, I had to leave a bit early, but you know how it is. Everybody comes back from school and the whole house looks like a car crash. Um, but I was into the night. I was kind of thinking a lot about all the presentations, and this is really a blessing. And I just hope that at some stage we can recap this in person. And I'm not giving up on that. I'm not looking.
Gilad, can you speak louder? I can't hear you clearly.
Is it better now?
A little bit.
All right. I'm just saying that the conference, I mean, I really love the conference. I'm learning a lot. Um, and I'm just hoping that we can somehow not give up the idea of doing this in person at some stage. Um,
Sorry.
I mean, that, all things being equal. Do you want me to share my screen, Jan, or do you wanna run it from your screen?
You made you co-host, so you should be able to share your screen now.
All right, let me try this.
Yeah.
Can everybody see my screen?
Yes.
Yeah? All right, wonderful. Um, what I'm basically going to try and do is walk you guys through some of my thinking in the last 12, 13 years about the question of how refugee law, international law, and halakhic Jewish law come together. And I want to kind of recap at the end what at least it means to me, in the sense that I look at it as a living thing, both at international law and at halakhic law. And I think it has high relevance to us. And I'll try to walk you through the way I see it, where it has gotten me thinking. I've slightly modified the title not only for East African migrants, but also for refugees in general. And through the presentation, you'll see why, because the nexus between refugees, especially when you read it halachically, the word palit, we will see that it has direct connotations to the issue of war. And therefore, bear with me here. I started this about 12, 13 years ago. And this began basically as a PhD, after being a UN diplomat. When I witnessed the African migrants coming to Israel, you know the story. And that brought me to look initially at who wrote the 1951 Refugee Convention and why did Israel find itself in a sort of a weird condition that it was bound by a convention that pretty much, in the Israeli-Palestinian case, everybody sort of didn't pay too much attention to. And that got really to the book which won the National Jewish Book Award, and the articles on non-refoulement, where I suddenly found out that it was, well, not only Israel who wrote non-refoulement for everybody, but it was in fact Agudat Israel. So the representative of Agudat Israel, Rabbi Yitzhak Levin, at the time in 1950, was the guy who actually wrote what we know as Article 33 of the 1951 Refugee Convention today, which is the prohibition on refoulement, the prohibition of sending back refugees back into the hands of their tormentors. And at the time, what was interesting was that Yitzhak Levin, who was an ultra-religious, ultra-Orthodox Agudat Israel representative to the UN, the son of the chief rabbi of Poland, Ron Levin, fled from Poland by the scuff of his neck from the Holocaust, finished his career as a professor at the Yeshiva University in New York. He framed non-refoulement at the time in the making of the 1951 Refugee Convention within a nexus between Jewish halakhic law and international law. You see it at the bottom. The expulsion of a refugee. He quoted the book of Amos 9, and he said, it is obvious that since Amos reprimanded Gaza and Tyre, which were not bound by Jewish law for that sin, the sin of sending back refugees back into the hands of their tormentors, he considered that the act was a violation of international law, and that's the way he saw it from the halachic side. There's a methodological point which is interesting to note here, and that is that this entire source does not exist within what we call the travaux préparatoires, which is the preparatory works of the UN to the making of the 1951 Refugee Convention. So it was struck out of protocol, in fact. I found this in the archive of Agudat Israel. It's interesting to note that it was struck out of protocol because at the time, this sort of halachic way of thinking didn't the people who built the protocol for the UN didn't see it relevant. But at least the nexus here was very clear, and I thought it was a one-off case where halakhic law suddenly meets international law, or in fact sort of gives impetus to international law to do something, in this case non-reform. Then I went to become a Marie Curie fellow at the University of Verona at the law faculty for 3 years, and I wrote here in Germany we have what we call a habilitation, which is sort of another degree after a PhD before you want to become professor, where you need to do a habilitation, and that was this book on the Fourth Geneva Convention for Civilians, where obviously 3 Holocaust surviving Jews actually wrote it for everybody else. The president, Georges Cahen Salvador, was the vice president of the Conseil d'Etat in France to René Cassin. The head of the Soviet bloc, a man called Dr. Nissim Evorach, who was a good friend of Lenin, and the man who was most responsible for the humanitarian side, a Danish famous Jewish jurist called Georg Korn, who wrote the prohibition, for example, on settlements, but also prohibitions on death penalties and so on. But the interesting thing was here, for me, that when I got to the third part, so the first part of the book deals with humanitarian, sort of a base humanitarian idea for all, a threshold for humanity, which is Common Article 3 of the Fourth Geneva Convention, and then the illegitimacy of occupation. And then the third part is really the issue of application by courts, which is a rather problematic thing, in the Fourth Geneva Convention being the first instrument post-World War II where universal criminal jurisdiction was thought of, and that's the grave breaches clauses of the Fourth Geneva Convention. And that found its way into a second time, which I finally met Halakhah in the Kahan Commission, which is this little picture. And it's interesting to note that it's rather relevant seeing that this character who's sitting here, Aaron Barak in 1982, as we're sitting in this conference, he's suddenly finding himself on another bench by certain people who didn't actually want him to be on any bench, but I'm not going to get into that. But actually, for me, the more important person in this picture is this person here in the middle, a man called Yitzhak Khan, and I'll get to him in a second. For people who don't know, the Sabra and Shatila massacre, September 1982, Israel controls West Beirut, and the Christian Falang are let into the refugee camps after PLO combatants have already left, and they slaughter a few thousand women and children, which creates a commission of inquiry chaired by the president of the Supreme Court, Yitzhak Khan, with the vice president, Aaron Barak at the time, and General Yonah Efrat. What is interesting to note is in the Khan Commission, suddenly, and this is most probably the way we know the drafting of the Khan Commission, this was let into the Khan Commission report by Justice Yitzhak Khan. And Khan suddenly, out of the blue, in the report, when he finds Amos Yaron, Rafael Eitan, and Arik Sharon indirectly responsible for what happened in Sabra and Shatila, Yitzhak Khan finds it relevant to quote the whole question of what we call in Hebrew Eglah Arufa, which is the beheaded heifer, this idea in Parashat Shoftim, in Sefer Dvarim, whereby there is a direct responsibility of the courts, the elders at the time, to people who are dead, who no one knows, right? A corpse which is found. And what do we do with that? And of course, this entire thing is quoted in the Khan Commission, especially what Yitzhak Khan brings in, which is the famous issue of Rabbi Yoshua in Masechet Sotah, where Rabbi Yoshua says, can we imagine a condition that a court is shofchei damim, that a court is a spiller of blood? And Rabbi Yoshua says, no, what the point is about the whole beheaded heifer question is this idea that for people who are dying or dead, there is a responsibility of the state. Now, where do refugees come into it? The whole context of Parashat Shoftim, and especially of the person who we don't know whose body is or where he's from or where he's gone or no one recognizes is very connected to the issue of refugees because they are often not accounted for within the system. And here we have to go to Rashi to understand that the word palit, which first appears in our Mikra, in our Bible, in Genesis, I remind you, Abraham and Sodom, vayavo palit, right? That refugee. Palit says, Rashi very clearly in Bamidbar Kaf Aleph, is that person which is fleeing the sword of war, right? It's not any migrant. When we speak of plitim, when we speak of what we call refugees today, our Rashi very clearly states this has to do directly with the consequences of war, and therefore it is not an accident that the whole beheaded Haifa question, Parashat Shoftim, the next parasha afterwards is of course the laws of war, Parashat Kitetze, but the laws of war begin already at the end of Parashat Shoftim. I remind everybody the calling over a city for peace and so on and so forth. This context is very refugee dependent, which caused Yitzchak Kahan to actually put this into, and non-accidentally for the people being killed who were refugees in Sabra and Shatila, into the Kahan Commission report. And this brought me then to a bigger question, which is the question that Jonathan mentioned on the article that won the Spotlight Award for the Journal of the History of International Law on, the Jewish disproportionality conundrum. Why is everything written by the Jews after World War II? You have all the treaties over here on your right. Everybody in green are people who got a dual education. That is to say, if you look at it here, then Leo Paswolsky wrote the UN Charter, or Lauterbach, Lemkin, René Cassin, Georg Korner was a rabbi, Robinson, Yitzhak Levin himself, Louis Henkin. All these people got a dual education, rabbinical education, Central East European Jews, together with a doctorate in public international law. And here I must connect this to the slide above, which was the Kahan Commission, because Yitzchak Kahan comes from the same place, Brody, as Herr Lauterbach and Lemkin, goes to the same school, which is the University of Lemberg of Lviv in 1928 to study law, of all things. And we've all read the Philip Sands East-West Street book. And then comes to Israel in 1935. So he's coming from the same context. As to why it is the Jews, you can read the article of what my assumption is for it. But that sort of gets me from this point. That gets me to the next question of, within refugee law, obviously, we know the most vulnerable category within the Torah, 36 times mentioned, right? And the Talmud already asked, why is the migrant, right? Why is the migrant so well protected? And that famous answer, this nexus between Jewish law and international law, to which I'm constantly referring to, and that was one of the ideas of the article in the Journal of History of International Law, also has to do with the similarities between these two legal systems. And there you have it here. There are 4 similarities which make it very special for why all of these Jews coming from a rabbinical but also international law background from Central and Eastern Europe might have been recognizable, might have been easy for them to understand. Both legal systems being devoid of a living legislator, right? If you think of Germany here today, both systems rely on judicial interpretation to go forward. We can't go back to the legislator. Both systems are averse to what we call the judicial non-liquid. Non-liquid is a condition where a court determines that it cannot rule over a topic. I'd like to remind everybody, for example, in Germany, there was a famous non-liquid in the 1960s on whether marriage of gay people should be allowed or not. That finally went to the court, the Verfassungsgericht in Germany, referred that back to the legislator and said, that's not our decision. You're the living legislator of the Bundestag, please decide. That cannot be done in Jewish law because there's no legislator to go back to. In international law, there's no legislator to go back to in the sense that you can't, try reforming the UN Charter, for example. It's interesting that the ICJ, that same ICJ which we're discussing, Israel and Genocide Convention, which exists 100 years, 1920, it's PCIJ, it's the same court with the same statute. For 100 years, the PCIJ has never got to a non-liquid. In a docket of thousands of cases, the closest I ever got was the advisory opinion on the use of nuclear weapons in 1996, to which finally the president played the primus inter pares. And lastly, both systems are notoriously prone to limitations of coercion and effectuations of their rulings, something which Jonathan referred to yesterday in his research back to the 18th century. Another point which goes back into now I'm getting deeper into the intricacies of Jewish law and international law in terms of the linguistics. And this is again something very special that we get from halachic law. Anybody who sits on a Saturday like I do in the Knesset, especially if he does it in Frankfurt, it's pretty common to see, and I can see it, my son is about 16, I can see the way that he travels in different languages at the same time. He travels between German and French that he studies at school and English, and then he reads Hebrew, and then he looks at the Aramaic of Onkelos, and then he reads Rashi, and he sort of plays around with trying to look at where Rashi actually spoke French and where he spoke German when we know the Rashi commentary. This issue of the way we read, and this is very important. This is Jacob Robinson's book on the UN Charter, and he was famous in the 1951 Refugee Convention, for example, to coordinate the French and English texts. Why? Because he was a polyglot who spoke 50 languages, but he already points to this issue of the problem of the UN Charter, 5 languages which are legally binding, and he says we had problems with 2 languages in the League of Nations. Now we're going to have problems of more. I want to go back to this question of the intricacies of legal wording, which is why I think these living documents are interesting. And to go back to this issue of ger, which is this, again, refugees. And again, this issue of the rather revolutionary concept which the Torah had at the time of one law for the ger, for the foreign, for the migrant stranger, and for the citizen. And it's interesting to note that within this question, and ger, by the way, and you have it, the Rashi one at the bottom, because the issue of later of ger tzedek and ger toshav comes later, but Rashi, who is I don't have to explain to anybody here his utmost authoritarian, the authoritativeness of Rashi's quote. When Rashi says kol lashon ger in his commentary, you can be sure that he went through the entire Bible to look at every single instance where that word came up. And the only thing he says for ger is someone who was not born in that country but comes there to reside. We would probably call it a sojourner these days. But the translations wouldn't have that because séjourner is a French term. But the interesting thing here, beyond the word ger, and this is where I'm going to sort of wrap up in a minute, is not so much the word ger, which, okay, the foreigner, and even the revolutionary side of Jewish law, and I'm going to connect it to things which are happening here and now, the equation of the ger to the ezrach. I think even more interesting is to look at the word ezrach. So ger, lagur, that's pretty easy, someone who lives somewhere. But the word ezrach is even more special. And why? Because the word ezrach in Hebrew, right? Notice the translation. The new translation, right? The complete Jewish Bible said citizen of the land. Very clearly, the word citizen, ezrach. The King James Version, which is the famous 17th century Shakespearean time Bible, that he who is born in the land, which you ask yourself, okay, where exactly does the King James Version take this issue of birth for Israel, right? The Torah is already being a jus soli. You're born, so therefore you're from the land, and not a jus sanguinis. And the point here is interesting to note something about the concept of Jewish law of citizenship. In virtually all of our Occidental languages, Latin, civitas civitatis from cive, a citizen is connected to a city, to some sort of urban life. A polites in Greek, from polis, same thing. A Staatsbürger in German, from Stadt, from city. All of our Western notion of citizenship connects to some sort of urban or urbanic way of thinking, where the urban and the rural are different, because urban are as if freed people, while as rural people are serfs or whatever. That connotation of city life in citizenship does not exist in Hebrew, and does not exist in the word Ezrach. The word Ezrach, the source of it, is in fact an old ancient Akkadian source. The verb is sarach, from Akkadian, which implies autochthony. It's a botanic term, delineating a tree which grows out of its natural soil. And that is why, for example, in Psalms, you have this rather weird combination, ראיתי רשע עריץ ומתערה כאזרח רענן. If we would translate this into modern Hebrew, אזרח רענן, a fresh citizen. That doesn't make any sense. Of course it doesn't make any sense, because the term, and here the King James Version is actually correct, the Ezrach Ra'anan, the fresh, it's someone who lays roots, a tyrant, who lays roots to as if present himself like a native, fresh, healthy tree of the land. And therefore, and I go back to the King James Version of why the King James Version in the previous slide chose this citizen born in the land, right? Citizenship in Hebrew coming out of this issue of birth, but birth not giving you any special right above the law, which takes the ger who is living there, right, the foreigner, and the citizen to be equally subject to that same legal code. Why am I mentioning all of this? Because I think this is rather relevant to what we're discussing today. Here's stuff that's been going on. And I'm discussing only the issue of how migrants, refugees, and so on get to courts in different places. On your right, you have the famous demonstrations in Israel in 2013, where the Supreme Court in Israel revoked the decision by the government to lock up refugees from Eritrea and from Sudan. I remind you, go read that again. You see it also in my book. Many different quotes of Shimshon Raphael Hirsch and Yitzhak Amit, who I sincerely do hope becomes the new president of the Israeli Supreme Court, explicitly quoting Avraham and Genesis on the welcoming of migrants. But this issue of the court being involved in the coming of migrants in Israel is just as equal stuff which is happening now here in Germany. For people who don't know the context, in January 2024, there was a secret meeting by the extreme right of Germany in a little villa on a lake near Berlin in order to send away some 2 million Germans and non-Germans who are from a migration background. Sorry to be cynical, I often ask myself, why are these meetings always held in villas on lakes near Berlin? And I'm sorry for the undertone. That, of course, connects to the very recent, almost the same week when that happened, was the verdict of the German Federal Supreme Constitutional Court, the Bundesverfassungsgericht, which for the first time outlawed any state funding to NPD, which is the extreme right former Nazi party. And if you think that this is not relevant, then today, as of 2 hours ago, the High Administrative Court of Köln has just seen AfD's younger arm as constitutionally extreme right and therefore as a threat to the state. What I'm trying to show here is that this nexus between Jewish law and international law, our understanding of where exactly do migrants, refugees fit within society, and something to learn from this ancient legal code of Jewish law, when it is applied through the ages, at least to me, when I read those passages back in Psalms or back in Bamidbar, in the book of Numbers, and then when I go back to the first slide of Yitzhak Levin writing non-refoulement, I think that this nexus is alive and kicking. And I think that this connection should be more thought of as extremely relevant. We have in different places quite a lot spoken about the impact of international law on Jewish law. But I feel that we should also turn this thing on its head because of the longue durée and the disproportionate impact which Jews with a rabbinical background have had on international law. We should also look at the impacts the other way around, which is what is halachic Talmudic Jewish law thinking, what type of disproportionate impacts, in my view, they have had on the international law of the world writ large. And I'll stop there.